45.
Whose judgment?
That's all. Very much. In that matter.
We thus find that the Tehsildar sub-collector is neither a competent nor assumes power after the amendment having brought in 1922. Therefore, the decision and steps taken by them in issuing the said impugn notice or taking any decision subsequent thereto are without jurisdiction and cannot be sustained in law. He is directed to transfer all the records to mining department, and competent authority under the amended rules shall take a fresh decision after adhering the principle of natural justice within four weeks from the date of the communication of the judgment. Smile in the face of Mr. Dalai. Any other judgment? No.
To Annexure 1, he applied for the Dhania Stone Quarry Mines, and on 15/1/2021, under Annexure 2, he was declared as successful bidder. Thereafter, the petitioner approached the authority to approve the plan and to execute the agreement and to and other requirement. So, in according
The
to
blacklisting.
Yes,
You are the order of blacklisting.
yes, my lord.
Yes, you did not excavate the quantity. Now,
I have not
question is, that's the rule 12A.
my lord.
Dispatch or production.
Yes.
Temple administration.
Oh, this is the temple.
Temple administration.
Okay. Notice has to be given.
My lord.
Yes. Returnable after 2. Returnable in the second week of November.
My lord.
Next.
Item number 2.
May I please, your lordship? Lord, in this case, the poor Adivasi peoples of Rourkela, Lord, those have been displaced after the establishment of Rourkela steel plant, Lord. They were, some land were surplus, and that was decided by the authorities as well as the locals, Lord, by the Annexure 2, then by the Annexure 3 and 5, Lord. Then that should be returned to them for the establishment for them, Lord. Annexure 2, your lordship may see, it has been by Annexure 2, they have said in
What is your instruction? If there is a surplus land which cannot be utilized,
now
and
they are giving it to the private agencies, Lord. That is to be stayed, Lord.
where is their contemplation?
In Annexure 6, your lordship may see.
Annexure?
Annexure 6.
That is in 2021.
Sir, this is 2021.
No.
And you are in 2025 and so urgent that immediately an interim order to be passed. What you were there doing?
They are executing it, your lordship may see.
We do not know by this time the third party interest might have been created there.
No, Lord. What they are doing, Lord, slowly they are making the. They are asking
Sir, you know the one. The line of the judgment which says that the delay and laches can be attributed to the conduct of the petitioner, provided if there is any right created into a third party, then also. So interim order, when you waited from 2021, We can't.
Because now they're exiting, there is another, let them have status quo, at least both the sides, that can be done.
Sir, I say one word there. I do not want to repeat it here. Nothing. What, have you created any interest in respect of that land or?
Actually, to what is there in the petition, my lords, in the first paragraph, if I will read, my lords,
Mhm.
the land was surrendered to state government for the purpose of allotment to those families of Jhirpani resettlement colony to meet the additional requirement of house. My lords, what has been done after this is now?
That is what it says, that if that was not required,
Yes, my lords.
then in that event, they say that has to be reverted back.
Oh, my lords, that is not the land was desurrendered to state government as per this order, my lord. If there was the additional requirement, then only they were there.
I do not know
That
whether
is clear in annexure 5 million. That is why I am saying. That was the RDC, the locals, they have all them set together and they have decided in paragraph 1, pattas for, here let's see, pattas for homestead plots in resettlement colonies and agrarian lands would be given to the genuine claimants as per the procedure, and then the disposal of disputed plots number acre 171 of plot 5, Wailnagar would be discussed.
that
And
is
as per
what the revenue divisional
RDC, yes, Northern
whatever the RDC has taken a decision.
decision.
That does not mean that the government has also taken a decision.
Sir, there is a difficulty also. When you come to page 39, your representation, you have made specific prayer before the authority concerned.
He is the
You
Sarpanch.
have raised 5 issues, you have five types of prayers.
Oh,
So
unauthorized
that-
documents also he is making.
That would create many difficulties, sir. That is-
No. Give a response. Affidavit by 2 weeks, rejoinder by 3 weeks.
But- Item number 3.
Public interest litigation is a petition where the petitioners are facing difficulties for opinion number 8 to 11. I think
So it's a personal interest which has come. It is a personal interest which you are ventilating. Can PIL lies?
last time you also.
That is a different issue. But can it lie?
They are encroaching.
This is
Our-
absolutely the deepest of respect and humility. The PIL is being misconstrued, misunderstood to the greatest extent.
What I am submitting, my lord.
If your civil right is invaded, you can definitely go, your remedy is elsewhere. Public interest litigation.
That is a village road, my lord.
That's your access is impeded. Then
No, they are throwing the fish, they are running fish business, encroaching the fish village road, my lord. That's the whole difficulty.
whatever. Yes.
My lords, as per last order, the
Right to hawk is also a fundamental right. Supreme Court has said.
Village road, my
Now there is a act, street vendors. I think the act is also there.
That is
So-
meant for urban area, not rural area.
Whatever the rural area, somebody has to understand.
But clearly indicated.
Well, it's as per annexure page 28, the petition number 7 had approached this honorable court before, and as per 5, if I may refer to page number 29, my lord.
Yes.
The para 6 last line.
Yes, my lord.
That's why he
Yes,
has
my lord.
filed.
I am coming.
He has filed PI.
We are coming.
Yes, my lord. As if
The
I
judicial order.
my lord,
That's why-
last time, my lord, this instruction was forwarded, wherein the allegation which is mentioned in the PIL and not true, my lord. The allegation with respect to it is near the school, that is not correct, my lord.
That-
File your affidavit.
Yes, my lord.
File your affidavit. If it is all wrong, no difficult. 2 week, 1 week, 3 weeks hence.
Your lordship have a glance, my lord, at page
Item-
23, my lord.
Have you heard the stat? If they say that whatever the facts you have alleged is wrong,
My lord.
so let them come on the affidavit. Let us see whether they are truthful or you are truthful, both we have to consider. So let them come on evidence.
Item number 4.
Last time, also directed trust comes into open also file an affidavit. Whether the decision has been taken. Regarding
Let's if I may,
what is original this?
instructions will be. Recently, he has.
We are supposed to file an affidavit. This instruction,
Manoj,
I have been very liberal because I find that this is a practice which has developed for so many years. But nothing, because this cannot be treated as a part of the pleadings.
One week.
When there was a direction for filing an affidavit, why you peoples are not filing an affidavit?
1 week time may be granted.
Well, there was 1 week time granted to you. I think more than that. After the Durga Puja vacation.
They have the order 23 September. Very clear. On your submission only it is recorded. That affidavit you will file. You see paragraph 1. May not be you in person.
No, you
I'm
means
telling you,
judicial- judicial
panel,
side.
yes.
So that has decision. This is a decision which has been taken.
Last one, that now that he has
Now he has to pay off the entire. They say that if you pay off the entire dues and unutilization fees for last 5 months, they will immediately take steps to allow you to commence the distillation in your own shop.
Let the copy be suppressed so that I can.
I'm recording in the order. I'm recording in the order, castigating the role of the authorities in using this kind of a communicating letter instead of filing an affidavit. No, I will be. and-
Let's take Manoj to Wednesday, Manoj will file an affidavit.
But the order was very clear,
Let me understand, Manoj.
appearing for the state police directed to submit an affidavit disclosing as to whether any decision is taken by the competent authority on an application. You would have taken it as a part of the pleading and then decided.
Manoj, Wednesday, Manoj will file an affidavit.
I think that this morning is not very good. What is this going on?
Manoj, I apologize. Manoj, I'll file an affidavit by.
Affidavit or should be recorded?
Manoj, I'll-
Let them file affidavit so that she can.
Once as Wednesday, Manoj, positively, Manoj, I'll file an affidavit. That Manoj, I wish to know.
You should not have,
Should not have
Applied this.
accepted it.
you should have submitted that on instructions. If you have not filed any affidavit. When you have categorically observed in an order, then we are also to comply with our orders. How can we close our eyes? You have to be very careful.
The difficulty, madam, I am telling you, suppose if these statements are recorded, say the perjury or
So that they'll play.
Now, in view of this,
So that they'll play.
now, in view of this, now we have seen,
I have no problem.
let him go do the need
No.
and come back on another date, so
Yes.
that in the meantime, matter can be sorted out between him and the department. Yeah, you can also instruct your authority, whatever he has, the lines in which
Matter kept
Please.
pending.
matter is kept pending.
I wanted to dispose of.
It's up.
Unnecessarily keeping the matter pending, that was, I was thinking about it after
Yeah,
recording all these things.
And at least during this vacation, he can do some business. Article 19, how can you throttle in this way? Whatever may the commodity.
D'accord. weeks from the date of deposit.
Item number 5.
Let the written structure filed by
Taken on record.
be taken on record.
Can I take that instruction?
Give a copy.
At the outset, with profound reverence, I may be permitted to plead my nose.
Yes.
Present is a public interest litigation filed by the young social activists and permanent denizens of nondescript village.
Your heart is still alive or beating. The heartbeats are still there.
Yes, ma'am.
Because you have said it has pierced. Something has pierced into your heart. That's why
The heart is, yes, ma'am.
in your prayer you say that reluctant and willy-nilly to address their heart piercing grievance. So that's why I say it's when heart is pierced, very difficult to come.
Yes, yes. I may be pardoned for my
No,
exaggerated.
impertinence.
Now the petitioners are young social activists and torchbearers of village Godapadara in nondescript remote countryside.
Non-descriptive.
Nondescript remote village within the in the outskirts of Balanga district.
Correct.
Balanga PS in the Tripuri.
Correct.
There the petitioners of village Godapadara having no personal and no vested interest in a last-ditch effort have been constrained to approach this honorable court for amelioration of the grievance that the government is
What
ruling
is the prayer you have made, sir? Is it the
a prayer. Yes, ma'am.
appropriate prayer for PIL?
Yes, ma'am.
Please tell me.
In fine, all said and done, the petitioners humbly pray this honorable court to admit the PIL and issue rule nisi calling upon the appeal parties to show cause as to why they are reluctant and willingly to address their heart
Is this a prayer for PIL?
or annex it to passing management.
You are a public spirited person.
Yes, ma'am.
You are a torchbearer.
Yes.
Let me another word be used by me. That's you are a whistleblower. But when you come with the PIL, will you not come with a specific prayer that what you want? That this is the obligation of the government. These are the direction or mandamus to be issued upon the government. This is a willy-nilly, reluctant.
No,
What is there? What is the obligation under the law?
passing of annex to Article 16.
That is the why I say is a very cryptic. It is not appropriate or I would say conducive for a PIL.
Yes, ma'am.
This is the reluctant willy-nilly to address their heart-piercing grievance, discontentment, dismay under annexure 1 and 3. What you have to say that what they are required to do is and what they are doing.
This should refrain from mulling the idea of bifurcating the village.
That a scheme or a direction be passed to do this, blah, 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 blah.
Yes, ma'am.
So, we have a very important role in a judicial system.
Yes.
Why you should be so casual?
I have the sole purpose is to not to indulge in the bifurcation bid.
So that is what you say. You have to come.
Yes, ma'am.
What is the significance of a hamlet?
I know because the Godapatha revenue village is a village of repute, and its population is 5,000. Its agriculture is the mainstay of the livelihood of the entire populace. The hamlet Antagonia is is situated in the very close proximity. Its population is only 300 to 500. They are having this emotional bonding since and
What is the, I just wanted to know that if there is this converted into a revenue, that means the habitation would remain. Population is not going to be disturbed.
no, minor, the resource rights.
The question is the certain resources,
Yes,
the certain unique resources. They would be diminished, they would be
yes,
ramshacked, or
Yes.
they will be destroyed. Ecological, causing an ecological imbalance,
yes, ma'am.
causing a livelihood or or impacting upon the livelihood of the many the inhabitants of those hamlet locality.
Yes.
Whatever, there is a case which you have made out. What is the uniqueness in this particular hamlet?
My sole grievance is that once the resources are diverted,
What are the resources? First thing is
the proposed move by the government, so they have to allocate certain funds.
sir, I am just asking you that one is that it is coming within the purview of the forest. Hamlet, I do not know, comes within the purview of the forest. Hamlet is something different. Now, question is that definitely it has got a natural beauty. It has got a the tourist attractions that they come. Just I have to visualize that whether complete conversion of the hamlet into another aspect, whether it causes any inconvenience to the public at large, and what are the constitutional obligations of the government? What are the constitutional obligations of the government?
No matter once the revenue village is another revenue village is created in the vicinity, definitely our developmental activities have been cut
What's
short.
the difficulty? The revenue, you are also under the revenue village.
Yes,
Another revenue village is created.
they're bullying the idea.
True. It's very difficult. I'm just
So in the era of resource crunch, those resources might be utilized for the all-round developmental activities of our village.
What is the concept of this revenue village? What is the concept? Let me
That-
understand.
The RIS circle is there, this high school is there, other important.
That means that if it is a revenue village or revenues coming within this array, then the development would be more because the different authorities have been entrusted to take care of the development. And this is a small place, so they can definitely pay attention more than they have to pay attention in a larger area. So that is good for the public.
But it is stone throw distance only.
So what?
Hamlet is at a very stone throw distance from.
What is the difficulty?
Your ground number.
Difficulty is that the
You do
resource.
not want them to be developed.
No, man.
This is what it appears that your intention is that let my village remain developed. All development activities must contain here. In the hamlet, if they create a revenue village, that will create a problem.
The public outcry.
What is the public outcry? I wanted to know what is the importance or the significance of a hamlet, why it is to be preserved. Just tell me.
No,
Public interest. Please.
I have enlisted the grounds for which I have filed this. We have
Your
filed
ground number C is incomprehensible.
Madam?
Your ground number C at page number 9
Yes, madam.
is incomprehensible.
Page 9.
The government's policy They have to develop each and every part.
So I humbly.
It is an obligation of the government
Yes, sir.
to extend the development activities in every nook and corner of the state. How can you disassociate one?
Over since time immemorial,
What?
they are having emotional bonding.
They
All
will
the
remain.
religions, all
The land does not evaporate.
Yes, sir.
It will remain the land. It never goes out. So
So my
where is the difficulty? You do not want it's a wastage of the public taxpayers' money
Yes, sir.
in the other public utilities.
So
If the utilities are provided to the public for their betterment, how can you a single person?
population is very thin.
Maybe
Only 4,500.
a individual is entitled to all protections. You can't say that I am 5,000 person. I should be developed more than a pocket of 200 persons. They should be ignored. What are you talking about? This is the way the PIL has come.
No, I'm not urging you, my lords, to ignore the claims of the inhabitants.
Why will you ignore the claim?
No, man.
Why we will not? This is a government for even an individual. We have come across in the newspapers that there are such remote places in the hill area where the electoral is only one. Yet the government has extended that facility that you exercise your franchise. For one person, the government has to ensure that he has a right to vote, which is a fundamental right. And you are talking about don't do it for them.
It's against the majority will.
Misutilization of money. We are hardly 300 people.
Again, we will
people.
be majority, my lord says.
No, sir. No majority.
So I am
In a democratic parliament,
I am wondering.
the decision appears to me, but the government is neutral. The
Yes.
government, even if somebody there, if they are the citizenry of the state, it's the obligation of the government to extend all facilities uniformly and without any discrimination.
Yes, I have wanted to withdraw.
This populate a very bad mindset.
The truth says that the election process will visit the area to demarcate the territorial boundary so that this Kantagoria gram can be declared as a new Moza. That is. So you want to stop all developmental and
Everything will be stopped. The citizen of the country, maybe they are less in number, but they have an equal right with the majoritarian.
Yes,
Not impede their developments.
I am permitted to withdraw.
Yes. Advise your clients accordingly, as the man said. There's no difficulty. Everybody needs all the resources or the schemes of the government to be extended to them. Can't deprive somebody else. Yes. File your cost.
Item number 6.
Say the public drains have been obstructed by the opposite part of 7 to 11, and the without the conversion of the land as per the OLR Act, and now they trying to construct a road, and the public authority is supporting under the fund of the Manrega. They are also there doing. My lord, this is the drains, the government laid drain. This is the starter.
Drain? What?
Drain. Now that is drain.
DRAIN.
Drain. DRAIN. Yes, drain. Drains.
Yes.
Drains of the government drain. It is the status of the public drain.
Is a-
Drain is then the roadside there is a drain. But
Is an
now,
open drain or a
yes, open drain. Drain there is a drain. Status drain, open drain. But now the opposite
Drain
part
now.
and the private persons is 7 to 11. they are in pouring, they are pouring some moss and that is maram and clay and sands only in order to construct an artificial road without conversion. This is a government land. It is real lordship see.
No,
this
who are they?
because it is a
Doing it.
public, this is a public,
Who is doing it?
there is a doing this is opposite partner 7 to 11.
Who are they?
Who are this is the private person, the others, the board,
First thing
the
is,
board,
if-
the villagers
that-
board.
if-
Yes, yes.
A person is doing certain things,
Yes. Who's not an authority?
doing certain things, which means that they will have some gain from them.
No, there is nearby.
If those are done for widening of the road,
They are the villagers. They are near. They are
what is
residing
the gain
nearby.
they have
Because
individually?
because they are residing nearby the drains. Nearby the drains, they have other road. But now they are trying to construct a
To
road.
have the access.
Yes, they have to access by without any conversion because the government led. There is a government
Can there be a conversion of a drain?
drain
Can it
cannot
be?
be converted. Drain cannot be converted. But without how they are constructing the road. So the petitioner, the public interest person, agitated before the authority, Tahsildar and video everything, but they are silent. And this is the and the they
What
are
is the utility of the drain there? Because it's a village.
villagers are there.
Is there a proper drainage system in the village?
Yes, drainage system because by this is the drainage system.
Where it goes?
It goes in goes means towards some other main drains, that is canal.
You don't have the data.
No, data is I have also analyzed the map. Your lordship see map 17 and also the map. This is the drains, everything constructed. The map has been prepared and the
Sir,
minor.
you can make it a covered drain instead of the fill drain. I understand. You can make a road over it, no problem. Let it go underground. With the system, if you this,
Well, it's
and there will be a.
Well, it's I've received written instructions saying there is no blockage to the free flow of the drainage water. And the road which is constructed is on the adjacent, and that is for the ingress and outgress of those people who are staying on that side, Malaj.
So,
And there is no obstruction to the drainage that is claimed in the writ petition, Malaj.
okay.
And also
So
saying
the
that
upper layer is covered
on the
or
side,
some kind of a right way,
right way only, right to way.
there is no disruption in the
No, Malaj, that-
free flow.
That's what is on this.
It's like a ramp being created
No,
for
Malaj.
an access.
Maybe it's like on the side they have on a kacha way, they have made a kacha way on the side, Manos, using Moram and
Because the Tahsildar they are supporting. Yes, plot. They let them file the affidavit on the plot.
He understands.
Yes,
He understands.
yes,
Now, the purpose of this public interest litigation, we got it.
yes,
Got it. Let us understand more clearly,
yes.
who have constructed.
well, the opposite party, no, private opposite.
Without your permission,
Well, if I may just,
if they have put a covering, I understand some of the drain, so that they can cross and can approve the road. There should be some kind of a permission, or it should be done by you.
it's like a
It should be
side,
done by you.
well, it's like a, what this instruction which I've received is, it's like a side embankment for their only passage, Melots, nothing else, Melots.
Sir,
Well,
if I can visualize the situation, this is the road which is going. Along the side of the road, there is a drain open drain which goes. Having some width, maybe of 1 feet, 2 feet, or a 3 feet, we don't know, but there is a width. Now, what if one has to access the road from his house, which is adjacent to the drain? Then he has to come a little away from there and then come. So what they wanted is that just put a something for over the drain
on one side and the other side, so that through that particular small piece of slab or something, they can cross the drain and access the road.
No, that is not their claim, my lords. They don't want anything, my lords, on that road.
Oh, that is what I understood. Is it not an obligation of the government to do? Why you will allow the private individual to use?
There is status of this land intact.
Yes.
You know, mine.
There is one word
Yes.
which is problematic to you. And which has gone in.
But if I may be permitted to file the joint inquiry report which was done, my lords, in this matter, because the other similar matters.
You just go there, click a photographs and come. If and give that, I understood it. And if the government undertakes this initiative, I don't think so there is any problem. If there is no disruption of the free flow, they cannot have, but on a public road, can an individual do something?
We can take instruction and get those photographs now.
That's the problem with it.
Yeah, information which you are indicating that feeling that some private person is given this which was undertaken. Today, rather Mahatma Gandhi.
Manarega, the government who has done it, they might have sanctioned.
Manarega, but for the road, but not for the drain. The drain, they are
It's not
converting the drain.
Have you understood what we say?
Yes.
Only thing is,
There,
I am also of the view that there should not be an open drain. Because
yes, ma'am.
when a foul water passes through the drain, it emits some foul smell, and which is not good. So if it remains covered for all
Yes,
time
yes.
to come, I think that will be more hygiene
Yes, water can also.
and everything can
Everything,
go from
everything.
there.
Attack we have done
Yes.
that.
No, they have not done.
Attack we have done that.
Ah,
Box.
yes. What is
Information which he has.
Which drain?
That government is supposed to.
No, they are not. I think what they're saying is. Yes, madam.
Yes, Manager. I'll file an affidavit, my lords.
Affidavit within 2 weeks.
File affidavit.
with photographs.
I think.
Yes.
Item number 7.
You have already supplied him the information under the RTA.
Yes.
Just item 7, I refer to short action.
Yes. Please.
Item 8.
See, if a restriction by way of public interest litigation, with a prayer that in copy of the governance of Dattani Road, the electric poles, newly installing electric poles should be in proper positioning. Without in proper positioning, they have started installing a new electric pole which endangers human life and property. And it also violates the road safety norms. Expert. In fact,
They are expert in the field of electricity connectivity and others. You are doctorate in not in electricity. You are done your doctorate in some other field, not this field. So
I have done several cases in human rights. I have filed more than 1,000 cases in human rights.
maybe, but the nature of the case.
Yes, my lord, the page number photographs is there. There are some places outer side of the right of way, they have installed the electric poles.
All the PILs are.
But it is also public utility because page number 15,
I have seen your first one.
yes.
Directing the opposite party to the forward and right to ensure proper positioning of a new electric pole
Yes.
presently located within the carriageway or unusable road area of the newly expanded Kapil Prasad Jatani Road in Orissa.
Yes, my
Okay, you say that it is situated within the carriageway or unusable road, the area.
yes.
Then you say that should be shifted from there to by relocating them to the outer side beyond the right of way
Yes.
with due observance. Means if it is here, you want it just near to a road.
No. There is a drain in between the road outside of the
The
road.
only thing is they wanted to lighten up the road so that the commuters there.
But it's not tightening the supply of electricity. Supply of electricity.
Sir, you say expanded Kali Prasad Jatani Road.
Yes, my lord.
So electric poles are
Already there.
there.
Already there.
What? For what purpose? For the purpose of transmission of the electricity
Yes.
and the light.
No, transmission of electricity.
Page 15 and page.
They can also lighten the road.
I have no objection on that, my lord. Yes. 15, 16 is okay.
Till the road.
Yes.
And
True.
this is the road.
True.
So
What is the difficulty?
So he says that it is accident proof.
No, my lord. 15, 16 page is okay. But page number 13 and 14, my lord, is free.
So that arrangement, if the arrangement is
No, my lord, it's the drain is the outer side of the road. And before the drain, it is there in the road.
Is the arrangement if not by the department, they will consider.
No, it's not already half of the.
Practically, they will improve and do as per plan.
No, my lord. As
So
of
we, how can we assess that?
we require the horizontal clearance and safety norms, my lord. Because there is a drain. I just want to.
There is a scheme, there is a law which prescribes that all the electric poles that should go in this uniform manner and no manner at all. Tell us.
Yes, my lord. I will make
Sure, the law.
yes. Indian Road Congress guidelines say that way. I will supply that. It's not unless.
Where is the law? Where is the law? Sure.
Already Indian Road Congress guidelines and other road safety issued by the Ministry of Road Transport and Highway. I'll provide that.
You place those material which is not before us. You will not place it. The moment you ask the question, you.
I have
You are wisdom.
in my ground.
Enlightened.
My lord, I have a
Will you
written
not,
ground.
will you not annex that particular guideline? Then say whether this guidelines has any statutory force.
Photograph it is clear, my lord, already half of the road.
Sir,
They have installed in the highway.
we are the citizen of the country. I
Yes,
think we might have visited various corners in parts of the country.
Yes,
We have noticed these kind of poles to have been installed there.
yes,
But for time memorial, when we invented the electricity,
yes.
These are there.
Yes.
Now, when you say that dish has to be removed, then there should be some study. There should
My
be
lord,
some
this-
research.
Why I
There should be
say.
some guideline.
Oh, you will need to put
Guideline.
in
There
some-
should be some statutory rules, norms framed by the government indicating that this should not remain there. I can understand. You have not made out any case. When we ask you a question that show us, is there any statutory document, you say there is a guideline, but you have not. And
Because
this is how the PIL is being filed here. With deepest of humility and respect.
I met the opposite party, they
This is
said
a
that,
very casual, I am not using another word. It's a very casual way of filing the PIL.
होता है the guideline में.
No documents, nothing, no research paper, nothing has been done, no pleading. Whenever the court question is put, immediately answer is made ready by the bar without any pleading.
But it is on the ground, my lord. I have written in my ground, but I am not,
Why you not annex?
I am applying for that, I will apply the question. By the way, it will be to take instruction on that one, because already half of the person is, they have installed the electric pole in right of the way.
I'm not saying anything. Don't take it amiss. The difficulty is that here I find that without knowing anything, immediately prompt reply would come from the bar, which has no support, which has no backing, nothing of that. Not even in instructions, listen. Immediately prompt answer. There is a guideline. There is a statutory provision. Next day, neither guideline nor statutory.
I will supply next day or any other
I
day.
have noticed since last 4 months, immediate reaction comes, yes, there is a guideline. Next day, when I say, where is? Nothing. Approach is taken from a different route.
No, no, I will supply because I have
But,
already. what I have not
immediately you
annexed.
say
I have not
something
annexed.
you do not know, nothing is annexed.
My grievance is forwarded to other opposite party. Opposite party. Grievance.
It's not wrong.
5, 6 paragraphs PIL, mine. Not, I have not.
And my representation is forwarded to opposite party number.
Yes. 2 weeks out.
Item 9.
Instruction, I will give him to take instruction about this.
What instruction? Nothing is needed. They will come and take instruction on here.
No, it's the primary duty, it falls for the party number 5.
Nothing.
Item number 9.
Always nice.
This matter was taken up twice in the kind of the annexure 8, at least 38.
Here you wanted a municipal corporation.
No, CTA. The CTA was petition by which method this was communicated to the police. But under annexure 8, and they have intimated, CDA has intimated the petitioners that because the since police force was not supplied, the eviction could not be carried on.
No, under law.
So accordingly, I have sought.
Representing CDA,
No, sir, CMC.
CMC.
Yes, ma'am.
What can you say?
This letter under annexure 8 was issued by the
Devashish Nair.
Vishal M.R.PATHAK. Okay.
You are not empaneled.
So,
You are not empaneled to represent CMC. You are senior.
my lord, I am also.
You are also CMC.
Yes,
counsel.
yes, ma'am.
You have got any instruction.
My lord, there is no requisition with CMC to act upon this because we have not received any.
Have you seen 25/9/2025 order?
There is order of eviction already passed against the opposite party number 8 and 9.
Yes.
Anybody is representing or appearing 8 and 9?
No notice has not been issued.
Lord, I have instruction for OP 8 and 9, but notice I have not been issued.
Notice, give a copy.
And so process.
Record, who will file the order letter?
By tomorrow, ma'am?
Name. I just wanted a name.
SK.
SKD.
SK.
SKD.
Yes.
Copy short.
Mr. SKD.
Qualified bidders. My lord, we can turn to page 388, annexure 4.
Nursing, we have instruction to appear for corporation also. Nursing, we have instruction to.
Civil supply corporation. The requisition for civil supply corporation.
For subsidy, we have.
Not two.
2 and 4.
Copy.
I'm sorry, let them take instruction because my lord may kindly say challenging my rejection as well as selection.
Which one you are there? If it's serial number 1, 2, or 3, Balikuda or Tetol or Nagatamas?
Page 389, serial 8.
Jagat Singhpur Block.
Yes.
You are
Serial number 1.
Alok, serial number Alok Panda.
Yes. Then serial number 3 is the OP number 6. Serial number 4 is OP 5. And serial 2 is OP 7.
So all they are rejected.
No, my bid has been rejected. Serial 1 and 2 have been rejected. Serial 3 and 4 have been selected.
Where do I get it?
Next page. Fourth sub-paragraph. Besides this, para starts. Besides these two numbers, besides the two numbers of bidders, namely Meghna Mines and Minerals Resources Limited and Alok Pand as a petitioner, apart for Jagatsinghpur block were disqualified in the technical.
He has not, sorry, you are not concerned. Meghna has not filed serial number 16 and 18 of your appendix. And you have uploaded the document which are not visible and readable.
Nothing is there as to which page is not visible. I have downloaded the entire bid document and included under annexure 1.
When this
This was published on 9/9. So immediately on the next date, under annexure 5, 10/9, I submitted representation challenging my rejection as well as till date they have not taken any decision. Let them apprise this honorable court as to what steps have been taken on my objection under annexure 5. My instruction is he has also filed another petition, but I could not get the number.
Notice of Title 6. Who is the tender issuing authority?
She is appearing for the tender issue 2 and 3. 2 and 4 are the tender inviting authority. She is appearing.
2 and 4.
Yes, 2 and 4.
What is that? Financial bid is open.
Financial bid is open now.
Yes. It was on 29th.
You should not appear for 3.
No, state is appearing. But that,
No. 3.
but that is represented by collector. The collector is the chairman.
Tender from
Yes.
27234 of 2025. It's the restriction which is in fact which will deal with the issues involved in the entire all the batch of the counter.
What?
It's a challenging bias of Odisha Panchayat Samiti accounting procedure rules.
Section 16, by read of the sections rules 16 of the Panchayat Samiti rules. They are in. Yeah, there for time. Submission for your lordship is this. In all the 3.
3 and another item in item 30.
1 and 2, because the virus is there. I think 1 affidavit.
One case we will file the counter and add up in all the other things.
2 orders lordship kindly state in this accounting rules. Accounting rules.
16.
Which is not overriding the act. Now you only collector have the power to override.
No, I had no opportunity to prelude that particular rule.
Let's kindly take up the writ application, the amended. Not available.
What is the rule?
But rule 16, your lordship. Rule annexed to our writs. Yes, we have annexed. We have annexed an old rule.
Page
Page 50.
This is the Odisha Panchayat Samiti.
Yes.
Bears rules.
Rules. Accountancy procedure rules 2000. Let's say that is 2002. That is not there. That has been introduced. That is annexure.
Rule 16.
This is the latest new law, not 2020.
Rule 16.
1 and 2, Lordship can. 1 and 2.
What is the difficulty? This is the modalities of payment order to be issued by the authority.
Yes.
But why it is offending?
Let me tell your Lordship why it is offending. Your Lordship, see, initially, Rule 16 of Orissa Panchayat Samiti Accounting Procedure Rules conferred a power on the BDO. BDO is the chief executive of a Panchayat Samiti. Your Lordship, Panchayat Samiti in the three-tier Panchayat Raj system, one of the constitutional body. Now, Panchayat Samiti in its hierarchy as a Samiti consists of elected members, MPs, MLAs, Sarpans, and elected members. Now, Samiti is the highest authority of the Panchayat. Now, chief executive of the Samiti is the BDO. Chief executive of the Samiti is BDO, who is subordinate to the Panchayat Samiti and chairman as well. Am I clear? Let's see section 19 of Panchayat Samiti Act. Panchayat Samiti Act. Kindly see section 19 of Panchayat Samiti Act. Thanks. I'm sorry. I'm so sorry.
Yes.
The executive of section 19 of Panchayat Act. The executive authority of the Samiti. In the chairman, it shall be his duty to have the resolution of the Samiti implemented through executive officer of the Samiti, means BDO. Then 2, the block development officer shall be the executive officer of the Samiti and subject to such rules as may be prescribed in this behalf shall function under the control of the chairman of the Samiti. Subject to rules, he shall function under the control of the chairman of the Samiti. Now, under Rule 16, initially, if your Lordship sees that accounting procedure rules, the power
is up to 2 lakhs. It is restricted.
Initially, it was
yes. The block development officer, above the same block development officer and the chairman
shall take the approval of this.
Fair approval. In the event there is a delay on the part of the chairman to sign, then it can be done through project director or a sub-collector or
absolutely
whatever. So this is what the modalities have come.
Right. Now, initially it was up to 2 lakhs. Initially. Now, by virtue of the second amendment, they have made 2025 amendment, they have made it, the cap is increased to 10 lakhs. Now, what we are saying here is, now we have a pure question of law over there. Your Lordship.
Rule has not.
It has been notified now. It has been notified.
It has been notified.
Now it has been notified. The challenge on which we are challenging it, Lordship will see section 57 of the Act. Panchayat Samiti. I'll just play 2 provisions. We'll place 2 provisions. Section 57, 24A of the Odisha General Council. Kindly see section 57.
Of the
Panchayat Samiti Act itself. Yes. The rule making power. We are while challenging the wires, we are taking your Lordship to the rule making power. Kindly see, the government may, after previous publication, make rule consistent with the provisions of the Act or carry out all or any of the purposes of this Act and prescribe forms for any manner for which they consider that a form should be provided. 2. In particular, without prejudice to the generality of the foregoing power, such rules may provide for the conditions also, your lordship may see, skip over conditions of the property. Yes, sir. Any other matter?
Regulating, second is regulating the duties, functions and powers of the service.
Correct. And all matters connected with carrying out provisions of the act, regulating elections also, any other matter which has to be made following the rule. Now, 3 is important. All rules made under this section shall be laid before the Legislative Assembly as soon as after they are made for a total period of 14 days, which may comprise in one or more sessions and shall subject to such modifications as Assembly may make during the said period. Now, admittedly, they have made this amendment in exercise of power on section 57 that your lordship will get from page 50. This amendment has been made in exercise of power 57. Now,
Not under 19.
no, they have made it under section 57.
Under section 19.
In exercise of power on section
19
57.
also empowers them.
That's there.
Prescribe more.
That's there. But they have exercised power on section 57.
That
Now-
I find from the preamble.
Right, Manor. Now, once you have invoked section 57, it is mandatory and compulsory on your part to place it on the floor of the assembly, consisting of period of 14 days. It has to be laid before the assembly for a total period of 14 days, be one or more sessions. Now, today, if you lordship see section 24A of the Odisha General Cross Act. 24A of Odisha General Cross Act, I have borrowed your lordship book. Since my friends have not got it. It's in fact, it's your lordship book, my lord. I have
Another book.
There you go.
62.
This is page 706. (24) capital A of Odisha General Cross Act. Provisions for laying of rules before state legislature. My lords, all rules made by the state government under Odisha Act.
Also 14 days time is
14 days time, just see below that, my lord, kindly see. It will not be given effect to unless it is placed. Right? So there is a tag there. So what I have done is,
Certain decisions of Honorable Supreme Court, I was facing one of the cases in taxation. Whether it is the notification, gazette notification, as an exemption clause. If it is notified in the gazette, that would be the effective date. Or if somehow or other 14 days period did not pass through, then that will invalidate.
that I'll explain.
So, Rajiv Gandhi electric so under that statute, there was a notification.
Yes.
So that was under challenge also. I was facing the
But let me explain that.
problem.
Yeah.
And this court held, referring to many Honorable Supreme Court judgments as well as this court,
Right.
Atlas cycles or something like that. I faintly remember. Those line of cases say that even if it has not passed.
Placed before the floor of the assembly, it will be given.
It is the gazette notification. It is only for the information to the members of the assembly or legislative body that such a benevolent notification has come up. It will not have any.
It will not impact the validity of the rules. His lordship is trying to say. Lord, yes, let me explain that. Your lordship must have come across this act also takes care of. There are rules and acts and provisions which say when those rules and acts will come into force. There are specific provisions which say that they did not be placed before the floor of the assembly on gazette notification they will come into. And General Class Act also provide that. So different kinds of rules and acts, they provide their respective procedure how they will come into force and operation. So your lordship will see when the statute or rules, rulemaking power provides that they will come into force from the day when they are notified in the gazette. As your lordship rightly say, they need not be placed. But where the rulemaking power act provides that they should be placed on the floor of the assembly, like this case here, section 57, read with 24A, General Clearance Act, that mandates.
What they have done is rules when it was framed, was it not placed, on the floor of the?
Never placed.
Never placed.
Never placed.
Never
And 24 is a clear prohibition.
Whether the cabinet itself approves it.
In the executive authority, they have done it. In this, on the side of executive power, they have done it.
That means executive powers means under Article 162.
62. So the point is, there are other points also your lordship will come across under the provisions itself. Since this is a financial power conferred on the Panchayat Samiti, it is Samiti only the whole and executive authority of all the funds. The Panchayat executive officer will discharge it subject to control of the Samiti. Ultimate control is with the Samiti. So what they are doing is that taking away power of the elected body, vesting it with the subordinate to the Samiti. Bypassing the.
What about 58?
50.
Government may from time to time.
Yes.
Review to ensure proper.
Yes.
The scheme of the act, what I find is that so far as the section 26 is concerned of the committee, which one? Sorry, 19. 19.
That's
of
19.
of the act is concerned. It simply says that the executive authority of the committee is vested upon the chairman. No doubt about it.
Kindly see 28 there are.
No, 28.
28 there are.
22. 28. You actually look at 28.2. The block development officer shall, subject to the control of the government, remain in charge of the Panchayat Samiti fund and shall, subject to such rules as may be prescribed, administer the same in accordance with the decision of the committee. So what is paramount is, my lord, with great respect, my lord, what is paramount is the decision of the Samiti. Now, I'll just take your lordship advert to the.
That is no doubt about it.
But-
Even this rule 60.
My lord, one for a second,
Rule 60 does not talk about anything.
No,
About the Samiti.
the pitfall
They
is
have
here.
completely bypassed.
Lordship may see the pitfall is in 16 itself, there's an inbuilt pitfall. It has a dangerous, my lords, cascading effect. Your lordship will see 16.2. First, my lord, 16.1 provides says that the chairman and the block development officer shall together sign, both of them will simultaneously sign and all that. Where 2, the collector is satisfied that the counter signature by the sarpanch in any group or in any case or group of cases have been unnecessarily delayed, he may direct the BDO to of the block development officer to get the bills signed by the project director, PD, DRDA, sub-collector and pass the bill. Now, I'll just, hypothetically, I am conceiving a situation where the quality, in fact, that I have a matter which a series of matters are being filed where the quality of work has been abysmally bad. And because they have been done in cahoots with the mallards, whoever have been selected by the BDO. Now the work is abysmally done. And the mallard, for some reason, the chairman finds that the work has not been done as per specifications, he holds up the bill. Once the 7 days period has passed, mallard, the collector might take it upon himself, mallard can pass the bill. So the ultimate kind of envision
No, I understand. What that's a very common impression one to generate after looking at this. this rule 16 really,
Really usurps.
intended to be brought in the statutory form to streamline the release of the funds or the payments paid to persons who have rendered their work to the committee or as per the direction of the committee. Because the committee, it may so happen, I do not know, where thinking on longer times or unnecessarily delaying the release of the fund to be genuine contractors or a genuine persons. So they, just to avoid that, because the subsection 2 which says when there it appears that there has been an unreasonable delay on the part of the chairman, then the person shall not remain stretch his palm before the chairman for all time to come to pay his just and the legal dues. So this is the mechanism which was provided that in the event it is found by the collector that
There is delay, collector will take over.
then he can get it done.
Yes.
You won't
That
get
at
a
least-
check and balance.
So this is what I find that this provision is there. You are trying to project this that by the virtue of this provision, the power of the executive authority of the Samiti is tacitly taken away, not impliedly, but tacitly taken away. And the chairman is merely a rubber stamp authority, having no powers to take any decision, whether the bills are genuine or bills are ingenuine, everything.
And my lord, the
Yes.
The top development officer.
factor
This
of
is-
10
this is
lakh.
what-
Yes,
Yes, my lord.
exactly.
And why this factor
Can
of
this
10?
not be by a legal fiction? Can it not be imbibed and construed using that definitely it is only the releasing authority when it is placed before it. But at least the decision to release the fund that still rests with the Samiti.
Yes.
My lords,
If it
there is
rests with the
another,
Samiti,
there is another
then
catch
how
to
the
it.
money is distributed.
That different.
No, my lords, there is another catch.
Archibald rightly got it.
They have increased the amount to 10 lakhs because most of the work of the Samiti is below 10 lakhs. I've given a list of the works committed in executed in various Samitis, it was below 10 lakhs. Now, I being an elected representative, I don't have the powers to supervise, to make payments for works executed by the Samiti itself.
That is what I'm saying, that whether the warrant which was issued by the Samiti has been completed or has been done is strictly in conformity with the specification.
Who is to see that?
Is definitely a decision left to the Samiti to take a decision. The bills are submitted, but the bills are to be scrutinized on the basis of the work which has already been done. So far as the issuance of the check is concerned, there is no difficulty. Is a Samiti chairman who will issue, or it is a BDO who will issue.
Yes,
It's
yes.
immaterial.
This is
It's
just a
immaterial.
kind of a
Only
check.
thing is the control and the supervise over the work under the Samiti should remain with the Samiti.
Right. Secondary party is a ministerial like them.
With the spirit of 73rd Amendment of the Constitution, how it was meant to be.
In fact,
Preamble
Well,
of the
in fact,
statement
if
of
your
the preamble
lordship
of
says 16(1),
reasons.
every bill or other claim for payment shall be presented to the block development officer. I am just out. I'm nowhere in the scenario. If it is presented to him, he'll disburse it. I have to, there is a dongle signature, my lords. It will be utilized. I don't have any, my lords, say in the quality of work.
No, dongle signature, unless you have that particular password. with you.
No, no, the BDO has it, my lords.
No, even a chairman has a unique password.
But they're using it, so it is presented to the BDO. This has to be.
Signature.
And my lords, your lordship is aware by the 73rd Amendment, my lords. Democracy at the grassroots level, I don't have the powers to control the works which are being executed by the Samiti, my lords. It's frustrating the very objective of democracy at the villages, my lords. That is a basic challenge.
28-2, my lord, would be, as my learned friend was placing that, 28-2 of the Act, my lords. The block development officer shall, subject to the control of the government, remain in charge of the Panchayat Samiti funds and shall, it starts with imperative.
We have, that also we have challenged. That we know, your lordship, that question.
This rule was.
That also we have challenged.
Rule 16 was, this rule was introduced when.
2007, lordship. 2007.
What you were doing for such a long.
In fact, that also has been challenged in another equity payment.
Yes, lordship, that is.
We are conscious of that proposition, your lordship will ask us. Because since you have accepted the 2 lakhs, why not 10 lakhs? So therefore, your lordship, no virus of a rules, no limitation is there. Number.
That's true, but still.
That there, but
It has been challenged.
it has been challenged. That's the reason we challenge that.
But from all
Your lordship will take.
I think then the first petition where they challenge the entire rule.
Yes.
Not the amendment.
Not the amendment.
So that should be the lead case. Because if the amendment is held constitutionally valid, then the question of amendment
Will become a secondary issue.
That you have to fight. But in the interesting part.
And
we have
just to supplement, my lord, my lord Justice Raman's query that notification gazette or floor of assembly, Suklal Munda will.
Plus is the.
Yes. Suklal Munda, lordship may see a recent judgment, Indian bench of the Honorable Court. That.
Plus it's Supreme Court 1979.
79.
But
Well,
there was a discussion in.
It is there.
But we have
We have got it.
What have been,
we have come through.
We have got it.
But Suklal Munda lordship, it's.
Suklal Munda, my lord, Jila Parishad amendment was struck down on the ground that it was not.
I am also looking into section 58 of the Act.
Yes.
Which gives the state government a power to issue directions, notification, administrative orders, which has the statutory power.
If they would have done that in exercise of 58, then that would have been different. When exercise 57 amended the rules.
We've also, my lords, circumscribed by the fire.
Consistent with, I have read it. But
Hawk's eye. Yeah.
I have read it.
That is the catch, maybe the catch.
But another thing, lordship, is that if it's Article 243G, it takes out the independence of the third Panchayat election.
That is not, sir.
But
There are two aspects. One is the financial autonomy. And another is a functional autonomy. So far as the functional autonomy is concerned, that has not been hindered, that has not been interfered. You are still an elected body. You want to make any development there, you are bound to do it. There is no inhibition in you, there is no restrictions. Your powers have not been abused, your powers have not been curtailed. So only thing is that so far as the financial autonomy is concerned, how far should it go?
Yes.
Is it an absolute financial autonomy? Or there are certain checks and balances one has to
Subject to check and balance.
undertake?
That is all.
That is what one has to understand. So don't say in a more broader sense that the functioning of or the society is a part is a particle one.
My humble submission, lordship, in view of Article 243G, they have enabled the provision, they have come up with law. Now they can come up with the rules.
Constitution of the committee and the functioning of the committee has to be done in that way. This freedom, this autonomy is always there. But obviously, so far as the financial part, it has a different facet of the thing. So one has to understand balance in this.
It has to be in conformity with law. Subject to rules they have to make, and that rule must be in exercise of the power conferred.
The law has to be interpreted in the more pragmatic manner.
Always in favor of the
So that the very spirit and the soul of the act, I mean the object and the purpose is not frustrated.
That's it. It has to be always read in favor of the legislature, subject to the exceptions which if you can bring to my lord's conviction. That these are the exceptions, your lordship will strike it down.
If the rule was meant to, my lords, check abuse by the Panchayat Samiti, it cannot create a unnecessary accent in favor of the authority also. It has to have a balance somewhere. 16.1 is probably a check on the possible abuse of power by the Samiti, if in certain cases not. But that cannot be stretched to that extent that it will create an unwieldy kind of a. I think that the Samiti has over dependent source of an income. The source of income is there, 29. Independent source of income, no. It is a grant.
It's a grant. Finance
State and central. That's clearly given in 29. Allocation of a fund. 29. Then the Panchayati Raj system.
Finance Commission.
That's true. Is under the Panchayati Raj
Yes,
system.
yes, yes. Allocation of fund.
Central and the state.
Allocation of fund.
Allocation of funds.
No.
Finance Commission article 101 lordship.
Finance Commission funds received.
Item 13 also, I have challenged an additional amendment, my lords. When objections were invited, my lords, we had said that as per the treasury rules, there has to be, if your lordship kindly takes up page 67 of WPC number 27724.
Let us see first, let us see the parent rule 16.
Yes, my lords. Here, no, they also have to answer this to your lordship because we have challenged.
Which rule?
My lords, there was the government treasury rule stipulated at page 67, provided that in case of a Panchayat Samiti, withdrawal shall be made only on check jointly signed by the chairman, vice chairman and block development officer of the Samiti. So when they invited objections for these rules.
Block development officer is also a part of the Samiti. He is also a.
Yes, yes, he is a member of.
Yes, my lords. So they said that.
Part is entrusted collectively.
Collectively on everyone, my lord. So we said that you cannot just allow presenting of bills to the BDO because the rules stipulate this. So when we raised this objection, they've made an amendment which we have challenged. They say that provided that in case of a Panchayat Samiti, withdrawal of PL fund amounting to INR 12 lakhs and above shall be made only through check jointly signed by the chairman and BDO of the Samiti. Everything else, my lords, below 10 lakhs, my lord, the implication is the BDO can do it. That is what we have challenged. So they also have to answer that.
The BDO shall be an official member of the Samiti. Section 15A.
I think what I'm saying, one of the.
He is an official member of
The constituent member.
Yes,
of the.
Post is created for this act only, CBD. No other act is posted.
Everywhere, sir.
Every block constitutes.
Once there is a fund allocated by the government, there is always check and balance.
Yes, sir.
Sure. And one nominee of the government
Has to be there.
also be a part of it.
But it's taken exclusive power lordship, enter financial power, ignoring all the elected bodies. That is what we see.
On a line, not related to the, it means that I generate income, but I cannot utilize.
Yes.
I am sitting over the fund, but I cannot touch it.
What's done?
I am head of the family.
Only a
My
barking
clerk will
watchdog.
spend. I am head of the
cannot
family. My clerk or accounting officer, he will spend it. I will not be concerned.
Generally, the white spends it.
Yes.
But the
He-
purpose of
he-
the
he-
lordship,
Obviously on your instruction.
has to be with my.
On your instruction.
That if that is there, then we have no problem.
no problem. Our supervision
If
must
that
be
is
there.
there, we have no problem.
They can bypass us. That is the whole purpose. Yeah, they can bypass.
But we will file the counter affidavit. But one preliminary submission I'm looking at. Lordship may kindly see 16.2 once again for a moment. File counter.
By this time I have memorized. If there is any delay on the part of a chairman.
Yes.
To put in his counter signature.
Yes.
Then it can be done
By the collector.
through.
Other officials.
That's the power of the collector.
Collector.
That's the power of the collector. That is
Collector's power is only to ascertain whether the chairman of the committee has unreasonably delayed in
Yes.
setting his counter. That to that part only.
yes.
And second is,
and
he's
he
not
may
a secretary. He will direct the signature to be done by some other.
Yes.
By the block development officer. So this is what is the extraordinary power which is exercised by the collector to meet an emergent situation. Whether such power has been conferred.
Not an emergency.
But why I'm saying, my lord, I have a reason to say that. Whether such power is in conformity with the provisions of the Act, that your lordship will examine. My lord may kindly see section 39 of the Panchayat Samiti Act. Of the Principal Act, section 39. That is the extraordinary power of the collector of the district. That provision specifically deals. And particularly with respect to the funds. Section 39 of the Act.
This is when there is a disaster or something, that kind of emergency.
The elected body is not there.
Or there's a electric gas.
Like the super cycle. In case of emergency,
Not a run of the mill.
the collector of the district may, subject to approval of the government, direct or provide for execution of any work or the doing of any act which a committee or its chairman is empowered to execute or do, and the immediate execution or doing of which is in the opinion necessary for implementation of development plans or safety of the public, and the direct that the expense of executing such work or doing such acts shall be paid out of the fund of the summit. And number two, if your lordship may
There is a
kindly,
disaster.
if the expense is not so paid, he may make an order directing the person having custody of the fund to pay it in priority to any other charge against such fund. Such person shall, so far as the fund in the credit of the committee, be bound to comply with such.
Is the power of dominance. I can understand the collectors in case of an emergency. Now, in emergency, it has to be understood. In juxtaposition with the ordinary business, transaction of the business of the committee. One, in a routine manner, something is done. One, because of an emergency, something has to be immediately done, because the committee is a conglomeration of the different elected members. It may not be possible in case of an emergency to have the meeting of the committee or to bring all the persons and then take a decision. So this extraordinary power in an emergent situation is provided to the collector that he can do it. But again, he is not an authority that will serve. He is an authority who can mandate the
Yes, that is what
accounting department that you just make the payments. He will not make the payment. It's an accounting department, on his instruction has to make the payment from the fund of a committee.
Yes.
Directing him. That's the power of dominance, the powers of supersession, the powers to be exercised in case of an emergency. When the head note says about the extraordinary power, that has to be understood that not in the normal sense, but only in case of an exigency.
Yes. That is what is.
That has no relation with 16.
But 16(2), where the collector is satisfied that the counter signature by the chairman in any case or the group of case has unnecessarily been.
So let us have the
direct.
example. Let us have the hypothetical. that a village within the purview of the Panchayat. Now there is a meteorological department has suddenly says that there have been aberrations and there is going to be a big sunblock that would really hit. And that may also cause the river to overflow. Immediate embankment or some checks and balances are to be done in the banks of the river so that it may not come and create a flood situation. Now, this has to be done overnight.
Yes.
So in that situations, it's not possible that all the Samiti elected members will come and sit and take a decision and the collector within his wisdom can immediately take a steps. He can do those safety measures to be placed so that in the event if any casualty or any of God or any kind of a tempest or a flood, if it is likely to affect, that would be arrested in that sense. These are the situations to be understood in that way. Cannot be done in all ordinary senses up to 10 lakhs rupees. Power is given. I understand one has to understand a distinction between a financial autonomy and the other functional autonomy.
But this -39.
What does a Samiti means and the Panchayati Raj system introduced in the constitution? One has to understand. Affidavit by which time? I think the pure question of how.
And 24A says that you will not.
Definition of the different provinces of the act and the rule.
In 24A says that you will not implement the rules till it is placed on the phone.
So
It's not implementable.
it's not implementable. Maybe tribal ones, they function as per the act instead of relying on these.
Or at least section rules 16(2) may be suspended for the time being. One may continue.
16(1) may continue.
One, what are you talking about? Two is a dependent one.
Yes.
And applicable in case of a contingencies or eventually.
Yes.
Why you are saying?
That's right.
Two.
What does it say?
One.
Don't create any unreasonable delay. No problem. Don't create. You are an elected body.
Or let them not bypass the.
That is only.
Let them function as per the act.
Let them also place it, whether it was placed in the house of the assembly.
Yes.
Or what was the object and
Let
the
them place
purpose behind the incorporation of this particular provisions. What was the reason for that? I think the bill or some notes must be there, so they will be placing that notes. The file has to be placed.
They have to place the file before.
Yes.
But Lordship, our every just move with the development works. Now it became a constitutional crisis.
Sir, you are not prevented from doing a development work. Sir,
But Lordship, they are.
when Rule 16 does not talk about, only thing is that you are prevented from putting your signature in the
Lordship.
check.
Lordship to super.
Nothing.
Supervisory power.
Everything is with you.
No, Lordship.
Because
Because
you're talking about,
Lordship.
only thing is the issuance of the check.
in fact, Lordship.
You do not invite the court to give you an advice what to do and what not to do. You know better.
Let us not pass an annual action plan beyond less than 10 minutes.
10 lakhs. At least
Because-
some factors should be there, Lordship, but they cannot misuse the power, Lordship, by taking advantage of.
What are you doing? It is a double-edged sword, sir. When you use this word, this can also be used for you.
Yes.
So that's true.
Let
That's
them
true.
place the file.
Center.
So
Bureaucratic interference.
you can't say. It is not. Ever.
Or at least or at least this much of a check can be given.
5 year 2 weeks.
But at least this much of a check can be given. Let them not supersede in case of any objections filed.
Let them not bypass at least, Lordship. Only that.
No supersession of any objection is recorded by any
Bypass the
member,
elected body, Lordship.
any elected body. Chairman. Elected chairman.
The option is
No, if
always in
it's-
favor of the statute, my lord, unless declared.
No, no,
They have to
objection is
take
part of the
declaration.
statute.
is yet to be declared, man.
Objection is part of the statute. Let them not supersede that.
Why you are inviting us to make some observations? You know what to do. Even this section is in place, you know what to do.
Let's let it there. Let's let it there. We have to educate all the everybody's. Education, right? That letter is there.
The Odisha Committee Authority and we
In 3 weeks.
Don't implement it.
Instead of 2 weeks, can I pray for 3 weeks? A week more.
You can do it within 3 weeks, you can do it within 3 weeks. Now you have understood that what is passing.
I have understood.
There is no difficulty. Reading is has a limited role. Only thing is you have to collect the files, you will have to just message. Everything you have to disclose that you have followed all the norms. That's the only thing you can do. Anyhow, 3 weeks.
Lordship, can you take a special urgent matter status so that issue can be the next state lordship can be. Because entire.
Instead, all that we can
Yeah,
request
state
my lordship,
goes
I
right.
kindly direct the state to produce the
Only
file.
because the galaxy of the senior lawyers are appearing.
Never lordship, issue is a constitutional crisis has been created in the whole state lordship. Lordship. Now the entire bureaucrats have taken over the entire institution. Lordship. Now the entire elected body is no more existence in the state.
What are you talking about?
Lordship, all the same.
No more?
No,
No, sir.
No.
I can't believe it.
Lord, all that we can request is, Lord, direct the state to produce the relevant file.
Fine.
But that they should do.
They
So that
will,
the lordship.
don't worry.
Same heading.
If they hide it, I know how to.
And in due
So
deference, they can go slow.
No. That's why I gave
With the
it
10
last
lakhs.
for 3 weeks so that I will ensure that within 3 weeks. it's
Right.
sorted.
Well, gratefully yours. First, item 13 is similar levels. It may be tagged along with this.
Item 12.
So at least
I'll
lordship,
give by
at least,
my lords.
at least lordship on the same heading. Lordship.
On the
Same heading lordship. Lordship. Yes, admission, right, same heading lordship.
no, I understood.
Yes.
Because there, because the system is of a motion. Yes. A fresh motion and the adjourned motion.
Yes.
Yes, sir.
So we are conscious that under the same category or under the same heading. I am very used to this idea.
Plus,
Don't worry, it will be taken up. Don't.
That's what also.
Plus, there is another rate application, 28955. I'll give it my lords second in the memo. That also may be tagged. Same. 28955. 20. Oblige.
Item 12.
Three matters are there, the second matter is mine, so I am arguing the first matter also.
You are not engaged in the first matter.
Yes, my friend is there.
You are not engaged in as a senior. Yes, you argue your first matter.
I can argue, sir. My senior can satisfy much better than me.
Sure. You are saying every lawyer is competent enough. There is no distinction.
Arrangement, similar process, three bidders.
I was ensuring something for you. Yes, yes, right.
Page 31.
I take the second matter file or a first?
The first matter. First matter.
He's arguing the first matter. Remember.
I think first and second both are related because the same Sudhanshu Shekhar Datta are the summary in this care of it.
It's for another, for the better, for the interest of the bar, nothing more than things.
Okay.
I qualify.
I'm entitled to a lighter note.
I'm okay.
276441.
Yes, ma'am.
Yes, you are
Yes, 2764.
The reverse auction
Yes.
process.
Reverse auction process I am
What
challenging.
is this? Reverse auction?
Yes, ma'am. Here the tender is for hiring of some services from me by the original person, the number one. He hires from service from me so that the auction process will be downwards. So if it is 100, who quotes 80 rupees, he will be preferred.
So auction is in the process progression. Here it is a regression process. That is why it is called reverse auction. I qualified in the technical bid. Technical bid. Thereafter, I entered into the price bid, and it was an online bidding. And it was there because of technical glitch. I could not enter into the site. Your Lordship, may kindly see Annex 4, page 31. Yes. Well, serial number 18. Right? Annex 4, page 31.
Serial number 18 means?
Serial number 8.
8.
Last one.
Say yes.
Last one.
OMM.
Yes, my lord. Own support services.
Qualified?
Qualified in the technical bid. Yes. Then, my lord, when I tried, your lordship may kindly say Annex 5 series at page 34.
Yes.
You are invited to participate in a reverse auction for monthly basis cab and taxi hiring services, premium so and so, so and so.
Yes.
And then, my lord, page 36. The reverse auction starts 12/9/25, 3 p.m., 15 hours, and it is to end 13/9/25 and 15 hours. Then, my lord, your lordship may kindly come to auto extension clause.
No. What is the date of this participants?
12/9.
This is pre. I think first is they invite tender for the technical aspect, and then fresh tender for the financial.
No, they invite us to go for reverse auction system online. Your lordship may kindly see page 36.
Yes.
Reverse auction start date and time
12/9/25, 13/9,
15
3 p.m.
Yes. Then, my lord, the third clause, auto extension clause.
There is third clause. At the bottom.
Yes, ma'am. If any seller submits the offer price during last 15 minutes of reverse auction end time, then reverse auction will be automatically.
I'm not getting this.
Page 36, my lord.
Yes.
The first is RA start
Auto extension.
auto extension.
Yes.
If any seller submits the offer price, the right side column, ma'am.
Yes, extended for next 15 minutes.
So if the last seller ups a price, then it will be extended for another 15 years, irrespective of 13/9/25, 15 hours. And
there is no limit.
No. And in the process, it continued, because 14th was a Sunday, it continued to 15th, 10 a.m. That is available to your lordship at Annexure 7, page 44.
14?
Page 44.
Yes.
This is my objection to the help desk of the tendering authority. I want to inform you that while participation in the cited subject tender was not open from 8:30 a.m. to 10 a.m., I have tried many times to open it by clicking on ongoing RA tab, but it was not open till 10 a.m. Later, check the said tender awarded to another party. And your lordship may kindly come to the previous pages. It starts from page 38, Annexure 6. Page 38. Yes, ma'am. Yes. 9:43 a.m. 15/9 towards the bottom corner, right hand bottom corner.
Page 38. No, does not say about it. There at the bottom.
Yes. 9:43 a.m. 15/9/25.
The site cannot be reached.
Yes, my lord. Then
9:47 AM, the next page 39. I have been constantly trying. Yes. Then 9:51, the site cannot be reached. Then at 9:56, site cannot be reached. And finally, at 9:59,
After 10, you have not tried.
Sorry, ma'am.
After 10,
Yes.
you have not tried.
No, because it was till 10 o'clock. Yes. Then, my lord, page 46. The responding to my objection, they have replied. Lord, we would like to inform you that a resolution has been shared to you for the raised concern, and we are waiting for your confirmation of the same. Kindly reply to us at the earliest. Please find below the resolution details. As per your concern, we would like to inform you that RA has been ended. RA end time is 15:09:25, 10 AM. So, my lord, before that, I have tried, but I failed because of technical glitch, so my case was not considered. That is the. Yes, what is the response? This for the JEM. Yes, JEM 1.
Lordship, I am appearing on behalf of GEM in this matter.
What is this? Your site was not, there was no access which was given to those.
Lordship, with regard to that, we'll have to take instructions because we are yet to receive the petition of the two writs, Your Lordship. On the previous occasion, when this matter was called, we have been served with a copy of the first writ petition, which is at serial number 12. However, with regard to these two,
The authority who issued the OP1. OP2 is.
Ministry of Defense, Your Lordship, and even in the previous order, notice has not been served upon the buyer. That is OP number 1, Your Lord, respondent 1.
OP number 1 is the requisitioning authority. He is the tendering authority. I have not seen the party's name. Sorry. That's the problem. It is the. I have to just get over it. That Chandipur Department of Defense, PXE, the Director of Proof and Experimental Establishment, situated at Chandipur, Baleshwar. Yes, you are representing
OP number 1.
We are representing 2 and 3, Your Lordship. That is the portal.
Might have GEM portal there. She might have.
That is the objection. You want to say whether portal was perfectly already.
Then
During that time, you have
the
the
gone with
documents.
that. They are answerable 2 and 3.
Yes.
If there was a technical glitch, then you should. And then the reverse is, I think, is like an open auction. Yes. That somebody is putting his price, then somebody is again putting his price and going down. It's like that. Yes.
Yeah, but
It's like an auction. Open
yes,
auction.
it's true, my lord. But in page 46 and 47, what I have gone through,
Yeah.
because I don't have any instruction. She is now.
You can't have.
But thing is this communication made from the GEM portal help desk with page 46 and page 47.
Yes.
They have given option as well as the help desk numbers. And if anybody is failed to do so, then what is the next course of action they can take care of in this process?
That is what he has submitted in writing to your mail.
Yes, that was after that they have also communicated. There is a part of the document.
So you responded afternoon. At 2:15.
2:13 p.m. Yes, that's correct.
So he immediately sent the mail to you.
GEM portal only. If say
Resolutions. What is this resolution? I'm unable to understand.
Resolution means they terminate my complaint, acknowledgement as a ticket, and how they deal with it, communicate to me, that is
That is
resolution.
what it really appears to be, because once they say it is closed, then open the ticket and all, everything. I was just thinking about it. What does it mean?
My
Lordship,
they raise a ticket, and how they deal with it, they communicate and say that it is resolved. That is a resolution. They have resolved my complaint.
Lordship, may I just clarify on this aspect? So, anytime any of the participants, any of the bidders, when they make any complaint to the help desk, it is an automated response wherein an acknowledgement email goes to the particular complainant that we have acknowledged your complaint, and then the same is forwarded to the backend team. So that needs to be verified from the backend team, Your Lordship, whether there was any technical glitch or not. Because since this is the matter of September, Your Lordship,
Oh, madam,
so the technical team
we
needs to be
understand
clarified.
that this is what is there, but equally we have to say that if you proceed, if the entire tender process has been decided, the contract has been awarded, then one has to understand that what is the situation.
Lordship, that is upon the buyer, that is respondent number one,
You-
because we are the
because you
intermediary
wanted-
platform.
What is your instruction?
I don't have an issue. First time it was listed, my lords. And moreover, this they should make a party to the person who has already been L1. I don't know.
He
Because
doesn't
they
know.
are disclosing so in the
No, they are not disclosing whom they have given.
yes.
They have not.
I can't.
He cannot get an access.
Lordship, the tenders that are related to Ministry of Defense are generally masked because of the security reasons. The Ministry of Defense related tenders are generally not publicly available.
As per the rules you started, then lastly, RA closed as per the scheduled time. Later, she was checked the JAM portal for the same bid, but unfortunately, it shows that another bidder become L1.
No, he doesn't know who is another bidder. How can he make a party? Unless he named it that who is the another bidder, how can he make a party?
Keep it to next week, then.
Yes, next week, keep it. To enable the council appearing for the opposite parties number.
Any-
28. Okay.
Okay.
No work order should be started.
If it is already issued, we don't know.
Then you also like clarification.
Let them. Let us see. Let us see. Let us see.
Or your lordship may say subject to result of this repetition, so that some protection for me at least, because I was prevented by technicals.
Let us first come. There are many things. I am not really making them wise. That's why I am keeping mum. I have checked the bottom also. Many things may come. I do not know.
I have a humble prayer, Lord. Your Lordship will permit me to make a just, Lord. Post lunch, I am not there. I am going. That's why you pre-model to excluded, Lord. Any day, sometimes I will.
Tell any of your junior when the matter is taken up. Just remind us, we'll do it.
But, may not.
Your name has to be recorded, don't worry.
If we were to extend, rather they will.
I understand. So, which point matter?
Item 36.
So don't worry. If we reach to the item 36, we will. If we do not reach, tell your junior to remind us at the time. So do it. No difference. Yes. What is this?
Challenging inaction of the director of serious crime. And under annexure 1, I got the valid lease for a portion of mines for excavation of quartzite and piezopolite. Now, while I was operating the mines,
What was the duration of the lease?
initially for a period of 20 years. Subsequently, under Annexure 5, page 36, it was extended up to 47 years. Annexure 5, page 36.
Okay. Then what happened?
Now, the difficulty is, Your Lordship, under Annexure 7, Annexure 6, page 40,
Yes.
there was a demand notice
Yes.
by the mining officer
Yes.
at page 40, Your Lordship.
Yes, yes, I've seen that.
Yes, Your Lordship.
1.64 crores.
Yes, Your Lordship. The mining officer under section 21(5) of the of the MMDR Act, they have issued a notice demanding 1 crore some odd to be paid as excess mining.
Correct.
Yes, Your Lordship. Yes, Your Lordship, kindly see the notice. The notice was under paragraph 2 has stated that pyrophyllite and quartzite, these two minor minerals have been brought into this notice under the MMDR Act 21(5). So far as, my lords, these two minerals are concerned, it are coming under the Odisha Minor Minerals Concession Rules, and this act is not applicable per se. Now, what is their stand?
This period is 2000.
2002.
2010 level.
Yes, sir. The past period, which I've been given the valid approval of my mining scheme. I was also allowed to excavate and also allowed to process in my factory and dispose of thereof. The past period they are demanding on the basis of judgment of the Honorable Appellate Court at page at para 4, Your Lordship.
Para 4 of?
That's the demand notice, Your Lordship. Annexure 6. I have to start para 3, sir. And whereas the Honorable Supreme Court in its judgment dated 2nd of August 2017 in WBC number so and so has observed under para 128 that the holder of a mining lease is required to adhere to the terms of the mining scheme, the mining plan, and so on. So I'm not taking the Lordship. Subsequently, against this order, under Annexure 7, I prefer the appeal. Before the director, Your Lordship.
Yes, then?
At
page?
Page. That is at page number 45, Your Lordship, 7, page 45.
Yes.
At page 47, my specific plea before the director was that, at para number 7, the government of India declared pyrophyllite and quartzite as minor mineral under 2016, and as such, our mines is governed by OMMC rules of government of Odisha, as we are beyond the purview of MDR Act.
Correct.
As of now. Now, Your Lordship, pursuant to my appeal, at Annexure 8, page 49, on 27th of August 2021, the OP number 2 issued me a notice to appear on 6th September 2021 of the appeal.
Correct.
Pursuant to that, we have not taken any action whatsoever.
You appeared?
Yes, Your Lordship, I appeared.
Yes. Then thereafter?
They have taken no action over my appeal. Now, under Annexure 9, Your Lordship, will find the division bench of this Honorable Court has already held that the quartzite and pyrophyllite, they are not coming under the MMDR Act. And so far as the judgment of the Appellate Court is concerned, it is related
common cause matter.
Yes, Your Lordship. It is related to iron and manganese.
So they say the entire exercise has to be completed within a particular timeline.
Yes, Your Lordship.
Then?
This Honorable Court held that the quartzite and pyrophyllite are not coming under the MMDR Act, but they are coming under the Minor Mineral Concession Rules.
Correct. So,
and
then what happened?
This Honorable Court directed the authority to again reconsider as to how this judgment is applicable to these minerals and whether they need to be imposed on the penalty or not for the specific period.
Whatever, true, then what happened?
Yes, Your Lordship. Now the difficulty which I am facing right now is that at Annexure 10, page 59, in order to apply for factory and trading license, I need to have the minor mineral due clearance certificate.
Page?
Mining dues. Annexure 10, page 59, Your Lordship.
It's not coming,
Yes.
you know.
Annexure 10.
No, I understand, but it is not coming in seriatim. It should come. 10.
Yes, Your Lordship. Page 59.
So apply your application.
My application, Your Lordship, certificate. Because every 5 years, my factory license and trade license has to be renewed.
True, then what happened? Then your application has been made.
11.
Huh?
Page 60 and 11. When I check the status of my application, then I come to know that a deputy-
Outstanding report is there.
Yes, yes.
Yes.
But despite all this, at least 61, Your Lordship, the demand notice.
So according to you, the demand notice has not been quashed by an appellate authority. You have approached the appellate authority. Now question is that unless that order is set aside, that order stares at your face.
But
And they can definitely treat it as a demand which is outstanding. Now question is that why you are not disposing of an appeal? Either uphold the order or set aside the order. Something has to be done on that.
Apart from disposal of that appeal, so Lordship will look at page 60 of that remarks column. Page 60, the MDCC application which is pending.
You say that the file is forwarded to the audit for the report of outstanding position.
So what they have not yet rejected his application.
That's
All
true.
they have
Only
pending
thing
for
is
the
that
audit.
there is an outstanding report.
There is an outstanding report, and now the file has been forwarded to audit for report of outstanding position.
Sir, I understand. You raise a demand, the notice was given saying that you have excavated in excess of what has
Yes,
been
that
provided to
he
you,
has preferred
1.64 crores. He has preferred an appeal. Now the appellate authority has to decide it. This court, while disposing of the writ petition, has held that so far as the judgment of the common cause is concerned, one has to understand whether it will come under the MMDR Act or it will come under the concession rules of 2016. So this has to be decided by an appellate authority. If that being the position, then you'll have to take a decision. You can't keep the matter for all time to come. And the appeal is of 2021. What are you doing? There was a direction to dispose of. Why you are not disposing of?
No matter. The judgment, if your Lordship may kindly see, that judgment is in respect of one Nimai Charan Das. Petitioner is Utkal Mineral.
Whatever.
Extra 7 is of 2019. And once you keep this appeal pending without deciding.
His appeal is pending. His appeal is pending.
So why? Why you will not decide it?
So even after that position is clarified by this court in a division bench, you keep the appeal pending and you are not allowing him.
Right first time. And you actually look to page 61. Even pendency of the appeal, they have extended. You actually look to that. So far as petition is concerned, page 61.
No, I appreciate it, sir. That is what I wanted. And how can they every time they will go on that there is an outstanding demand?
And that misinterpreted the judgments of the Supreme Court, which has been clarified by the division bench.
So they have to arrive at the appellate authority must immediately take a decision within 3 weeks. Take a decision within 3 weeks and whether the mining activities have been stopped.
Now it will be stopped from 20th because 20 is the last date of
20.
So for the activity is concerned, that is going on. But the trade license is necessary. That is expiring on 20th
For the
October.
issuance of that trade license, this
You also look to page 61. I think you also get the
MDCC
right.
application of the petitioner is pending, which is subject to the report from the audit, which is pending.
So what is this? The audit will definitely say that there is already an outstanding demand.
There is an outstanding. So the appeal has to be decided
And that is what I'm saying, that you indirectly they are put to, may I use the word, the catch-22 situations where they will go.
Where we say this.
Yes, I have seen that.
Last line also 6 months. This amount outstanding.
The validity may be extended for another period of 2 months. In the meantime, the appeal shall be decided.
Yes.
That is what I'm saying.
Right.
It should be extended for a period of that will not create any right into it. But
page 61 is of 2020.
Yes.
Page 50.
19 appeal was filed. During the pendency of the appeal, you passed this.
This Sorry, brother, this page 57.
57.
It is up to 2020.
2020, yes, that's what it is.
So now why, now we are in 2025.
And since I think it's pending.
Where is it? This page 57 was up to 28th of
Page 61.
say 6-1, 21. Where is the another one?
The other one I have not mentioned.
No, you'll have to annex it. This expired in 2021.
20th it was expired. I have specifically stated in the application, but I have not given that documents. Only for the purpose of making an application, this is required. Nothing.
For a period of 6 months.
For a period of 6 months.
Within that, I have to apply for trading license. Pursuant to that, I don't require it. Again, for renewal, I need to have another certificate for no use.
No, trade license is the issue. Now, tell me.
Now, issue is with regard to that no due certificate, Your Lordship.
So they have to decide the appeal. Otherwise, they cannot issue.
Yes, sir.
Then what will happen on 20th? We can't do anything on that because we find there is an apparent outstanding. The claim is there.
So far that claim is concerned.
No, that he has said that so far as the MDDR Act is concerned, is not applicable.
Right.
It can only be done under the OMFC rules.
Right, sir. And
therefore, it's the wrong authority who has the user the power which is not vested in him.
Right. That's it.
I understood.
That's it.
That is why we are saying now the court has said that you decide.
Well, can you also look again to page 61? I am saying so. Last 3 lines.
Page
61.
Yes.
Annex 12.
Yes.
This 1 crore 64 lakhs outstanding against the lessee of the licensee, which is stayed by the court of the regional authority or any authority competent thereof under Rule 22D of the MC Rule 20.
So it is a state.
That is according to them, it has been stated, but nothing has been communicated because we have preferred that way.
No, he is raising this page 57. I do not know. Where is the... Where is the 61?
Page 61, sir.
I am not getting 61. We don't have 61.
We have only 57.
Oh, sir. Annex 12, sir. Annex 12.
Annex 12, 57.
Sorry.
Our record shows.
Yes, sir.
Is 57, page 57 is Annex 12.
This is what is, I am getting it every time.
Yes, sir. I think there is something. I am extremely sorry. There is some
index change.
We check.
Yes, it says that it has been state. The demand is state. Mr. Das.
I to find out.
So
it only says, my lord, outstanding against the lessee, licensee, which is paid by the court, revisional authority, and any authority. It's not specific. What I am trying to say, it's not specific. Whether it has been issued or not, I'll have to verify with the authority what has happened, my lord.
Sir, you have extended the validity of the license that shows on the ground that it has been stayed.
What I believe, my lord, after the matter has been stayed, this MMDC has been issued in 2020, then in 2021.
He says that it is up to 2025.
2020.
He says up to 2025 because he is going to expire on 20th, where you have stated in your petition.
Yes.
But you have not issued given a
certificate itself indicates that this
it was valid for 6 months from September 2020, means in 2021 it expires.
Yes.
But he says that it is continued. I do not know where you have stated.
Paragraph 14.
If it has been
Paragraph
14 at page 12.
14. But sir, will you not annex the copy?
Only for the purpose of making an application, it is necessary. IPS is not required. Only for the purpose of making an application, no due certificate is necessary.
But this is an application which you have made on 14/7. I am just talking about that where you have stated that it is valid.
But my validity is there. There is no dispute.
How? And where? Where you have stated?
If I perhaps, my lordship, I have miscommunicated. The question is, your lordship, that in order to apply for the trading and factory license, I need to have no due certificate on the competent authority. It's for only purpose for, it's a one-time purpose. When I get that license, that certificate.
That is the MDCC certificate.
Yes, Your Lordship.
MDCC certificate which you have annexed is that expires in 2021. Thereafter, what you did?
Thereafter, again, after when I need to again reapply for the factory
When
license,
immediately in 2021?
not required because the license which I get is for 5 years. When again I have to reapply.
Sir, it is for 6 months only. So
the no due certificate is within the 6 months window, Your Lordship. I have to make the application for license, Your Lordship. Otherwise, it will lapse. Again, I have to reapply for the certificate.
true, this certificate of no dues was valid for 6 months. Thereafter, have you obtained a fresh no dues certificate?
After 5 years, I have to obtain because
Why 5 years?
because again I have to reapply for the license, Your Lordship, for trading purpose and business
So
purpose.
this 6 month certificate, once it is granted for 5 years, it's valid.
Yes, Your Lordship. Yes, Your Lordship.
No.
Stay is off.
Oh.
Expires. Stay period is all.
No, sorry, we can't do it anything. Now, you just give me, decide the matter within 3 months. Brother, that is what you just write it, within 3 months. No, sir.
You got direct electricity disposal.
3 months.
And also 3 weeks. So that's
Sorry, 3 was, I stand, 3 weeks.
And can I be permitted to?
Brother, you just dictate, I'm there. I will be
The case, so that I can move also pending a final decision.
Sir, in the appeal, you can, because this judgment came subsequent to your appeal. I have seen that.
Right.
So you can cite the judgment before this is not a part of the annexure. You can cite the law which is declared by the, go there with the template of it.
Only some observation.
No, it's not required. Why? Sir, you are a senior advocate.
No, sir, but the problem here also know that the authority executive.
Say they will take care of it. You know how to bring that in record.
The method related to the leaching of 180 ml bottle manure covered by.
When we can sit and take up all these matters. Give. Mr. Das is appearing in many matters. He is appearing.
I'm 16.
In this case, it's not.
Additional classroom in the school.
Yes, additional.
Why you are, sir, so much of, I think the reservations for construction of an additional classroom, it will benefit the children.
In a private plot.
What?
Project.
It is, are you a owner of the private plot?
No.
Then why you are so bothered? It is the owner of the plot who will say that my constitutional right under Article 100 capital A.
One of the plot is also complaining, madam.
Where is he? Let him come to the court. Let him come to the court.
He has already filed, my lord.
Where?
I had that instruction that he has filed.
Then let him, we'll decide it. What is your interest in this and how the public is involved?
Public involved.
Sorry, nothing is. They will take care of that.
My lord, public will be.
Public interest protection of the rights of the general public. It's an individual right. A right to remain remain a right to property is individual rights under Article 300 capital A.
Constructed. And then there will be legal disturbance will start, my lord.
What legal? Who are you to concern about it? You have started the legal disturbances, and then you say I want to avoid the legal disturbance.
Member of the managing committee, one of the member of the managing committee, as well as the guardian of this some students, my lord. One of the students.
So who are you to pose? An additional classroom is constructed for the benefit of the better children. And you are standing in the way. If it is constructed on an individual property, it's the individual who will come and say that without acquisition, without the property, how can they continue with the construction? I can understand. Who are you? You do not want the children should get benefit of these infrastructure.
Government plot is there, my lord. There is government.
When you every individual start coming that you do it this, you can't do it this, then the government will not run the administration.
We are agitating because of
Not
benefit of
like
students, my lord.
there should be some very larger cause which the government is bound to do it either under directive principles or under any other statutory obligations. I can understand, sir. He is public spirited person. It's a personal things you are bringing it to the court. I don't know. Sorry.
Benefit of the benefit.
If you have come for the general cause, then I am going class action suit. Go for order 1 rule 8, granting your leave. Go for publications and do. Let us see. Unnecessarily putting a spell. Let him come before the court.
There is school plot is also there. In the name of the school, name that the plot is there, my lord.
Are they selling a plot? Are they creating any kind of
without any
nothing? You can dictate. I do not want this particular thing to be constructed here. You construct here. Can you dictate
without demarcating the land, man? Without
can you demarcate? It's not required. You are not the owner.
Benefit of the students, my lord.
It's a benefit, sir. Additional classroom they have decided to. That means the number of the students are increasing. They wanted to accommodate them. And this is a more noble cause, and you are putting a spanner to it.
Suppose, my lord, the legal hurdles will come, my lord.
Are you not creating a legal hurdle now?
No, my lord. That person, my lord, that private
We
person.
have to go and decide the civil rights.
No.
Then what we'll do? First thing we have to ascertain it is a private individual plot or not. Are we not deciding a title then? Are we not? Tell me. You may say private individual's plot. Then we have to decide it. Arrive at the conclusion that it is a private individual plot. Then we are deciding the title in favor of a person.
I mean, next, my lord, there is a private.
Maybe, sir. If you don't know, subsequently he must have donated to him. He must have gifted to him. How do you know a third party? What he has done?
Villagers, my lord, that particular.
If I am the owner of the property, I will beat the drum of the entire locality that I am selling this property. So everybody should know. It's my individual right. I will sell my property. Should I beat the drum? What are you talking about, sir? The public interest litigation should not be misused in this way. Should we dictate?
It seems like against the administrators was taken up good cause. Yes. The representation proposed this.
The children will be benefited, more benefited by this. There were lot of accommodations.
It is not a public interest.
21, 22, this is 2021. And fifth one, end of this.
Item 20.
Thank you, my please, your lordship. I am a petrol pump employee, your lordship. During the panchayat election, 12 lakh rupees has been seized from me. So, my prayer is to transfer the jurisdiction of my PA case from Sambalpur to Bargarh, your lordship, because I am a tax assessee under the Bargarh circle, your lordship.
This is a matter of search. Yes, ma'am. So, the petition does not contain any communication from the information department. Only is approach the department for transfer. I will take the instruction what exactly 2 weeks.
Copy has already been sorted.
2 weeks he has to take instruction from.
Item 21.
May I please, your lordships? Lordships, this is a case where I'm challenging the jurisdiction of the officer in issuing the notice to me, your lordships. Lordships, my deceased husband's jurisdictional assessing officer is the Chennai assessing officer, your lordships. Lordships, may I show you his jurisdictional assessing officer as per the income tax portal? I filed an additional typeset of papers, your lordships.
The matter where you raise that a PAN number is wrongly given or something.
Yes, your lordships. Instead of putting my husband's PAN number, because lordships, now since my husband's jurisdiction is in Chennai, all the files of my husband are in Chennai. I do not know how the Orissa officer is taking the file and issuing notice to me. I might be one of the legal heir, lordships, but I'm not the only legal heir. And even assuming that I'm one of the legal heir, the jurisdiction does not transfer to the Orissa High Court. I mean, my apologies, your lordships, does not transfer to the Orissa assessing officer. And lordships, even the PAN number, your lordships, is supposed to be only of that of my husband's, your lordships, and not that of me, because you're then assessing me with an income of another party, your lordships. And then for the same assessment here, how will you then assess me?
I received the instruction. Next week I'll file it. I will already receive the instruction.
Lordships, I pray for a stay in this matter, your lordships. Even the revenue will be protected in this way, your lordships.
Revenue would be protected or the assessee would be protected?
Both of us will be protected, your lordships, because now there's no
Pay
demand.
the money and then how the revenue is protected.
Lordships, because it's still in an assessment, your lordships. So no demand has been raised. If there's no stay, they have to pass an order. So their time limit also gets extended, and we are also protected, your lordships.
Next week.
What about the stay of the proceedings? If we proceed, then what would happen? And the jurisdictional point she has raised, very competence. Yes. Yes. Starting your time to file petition and then stay your head for the time.
Lordships, it may be order of the court, your lordships.
Yes,
A stay may be the order of the court, your lordships.
what we have dictated. Order of the court.
No, lordships, I didn't. My apologies, your lordships. I probably didn't hear your lordships rightly. Stay is granted.
Mr. Mukesh Panda could understand.
My apologies, your lordships. My apologies. Obliged, your lordships.
22.
Your lordship, on behalf of Ms. Tripathi and platform for personal.
Then not this week. It's better to come.
Item 23.
May I please, your lordships?
Yes.
I come back as a bad coin, Your Lordship, as they say. So this is custom matter, Your Lordships, where I don't know whether the other side is ready because I'm told by my solicitor and record they have served them.
Last evening, I have received this copy and it's of time, my lord. For
Push. Why you do not serve it early?
Day before yesterday, they filed it. After clearing the defects, we have served it immediately. It's a voluminous document of nearly
So look at it, he's just showing that volume.
It was, we made 8 sets of it and we served on Union of Customs to the court and cleared the defects, got it listed somehow.
What, next week? Next week.
Lordship, I was, Lordship, next week Diwali holiday is not there in Orissa, Lordship, because in Bombay we have full holiday.
It's only 2 days holiday.
I have no problem, Lordship. I have no difficulty.
2 days holiday.
No difficulty, Lordship.
Right. Item 24.
The voluminous papers have been served. It's 2 weeks.
Item 25.
I have starting the order dated 11/8/2025 by the Honorable Single Judge.
Why you are challenging?
I was selected my personal to advertisement as a Ayush Ayurvedic doctor. For 11 months that contractual appointment was there. After selection, I was given the appointment, I signed the agreement and joined and served. While serving as doctor, my appointment letter was cancelled. The internet list was cancelled without giving an opportunity of being heard. I challenged this before Honorable Single Judge. Honorable Single Judge, as the opportunity of being heard was not given, that order was cancellation order was quashed by lot. But Honorable Single Judge did not allow us to continue, us to continue in service. My lord. Your Lordship, kindly see 11 months service. Your Lordship, kind complaint.
11 months has expired now.
No, it has not expired, my lord.
Not expired. When you were appointed?
I was appointed on 10/12/2024. 12/12/2024. 12/12/2024. Lordship, kindly see page 14, my lord. After quashing, this is the Honorable Single Judge that, however, it is observed that
You will notice who is for the other side.
Notice has to be issued to OP number 2 Miller and I.
Who is the joining authority? I mean,
joining authority is the CDMO Raigada.
Yeah. CPM or Raigada. Then why the notice has to be given to
OP number 2 Miller.
who is
The mission director.
Not Raigada.
He is under the mission director.
CDMO and PHO completed medicine director.
Who issued that particular letter of appointment?
Appointment as CDMO and PHO from district
What the
mission
mission director will do?
Let them allow then as per the direction of the.
We are in the process. He is asking for a notice and getting away. We are catching him up. Don't you realize?
Oblige, man. Oblige.
What are you doing, sir? Take instruction what to do. 2 weeks, issue notice on public party number 2.
Item 26.
May I please alert, sir? Coming to the petitioner matter, I have challenged here the annexure 6 notice of shifting of my IMFL also after issuing the license 8 days after the issuing the license. In the meantime, my lord, I have filed a I8 Part C, that is 15508 of 2025. I have paid to allow me till the end of the financial year to continue there. In the meantime, I will take all the steps to shift the arms off. What?
Lordship may be filed. Lordship, I have filed an IA and the SLC group with Lordship, the self-help group with Lordship.
They must have any copy to me, man.
Lordship, we have filed an IA.
What for?
Intervention application.
How you are interested?
Your Lordship, on the initial notice which was issued by the collector, it was on our representation, Your Lordship. If the Lordship comes to case number 11 of my IA, we had written to the collector requesting this running of this liquor surveillance. Thereafter, the collector had issued notice for shifting of the liquor.
I do not find. I think at the time of granting the license, the authorities have to invite any objection from the villagers and everything has to be done. And once it has been done, can there be a further objection? Under law, I'm just asking whether the authorities can do so. When the villagers at one point of time collectively decided not to raise any objection, some of the pockets of the villagers, can they come forward and say, and the authorities are going by the dixit of those objections?
Rule 33 provided
A particular
prohibition.
time period.
Yes, madam. There is a prohibition on the rule 33. Once the objection period is over, any objection filed that cannot be routine.
I'm really surprised with this. Every time in most of the cases I find, the authorities, they say, stop, objection has been raised by the villagers. At the time of granting the license, why don't you take the objections? Don't grant the license. Don't think so. There is anything. Yes, we don't. You can't do it in this way. Can't do it in this way. Where is that rule? Show us.
Rule 33, my lord.
Of
the Odisha Excise Rule 2017.
I think we have dictated one judgment in this regard.
Rule 33 is the sub rule 2, my lord.
Yes, tell me under what authority? You can stop. You can compel him to ship.
So therefore, my lord, I filed that IA to allow me till the financial year, I'll ship it.
Yeah, we are thinking of the larger release to be granted and you are
Sorry, man.
Make the let's make take of this
and it says that no objection received after the payment period will be entertained, summarily rejected. You could have rejected the objection. Why did not raise the objection at one point of time?
Your counsel is not accepted. Your counsel is not admitted.
What they have done?
They received the objection after the due date.
What, 2017 and renewed from time 2008?
Because the renewed from time, although these shops in question was recommended for
within the stipulated
no
period.
objection was raised against the counseling of the shop within the stipulated period after the process of renewal. A series of objection petitions against the said on shop was received by the district office. Then can you consider to that extent what is your statement? Then in 20.
We'll see to it. We'll see. I got your point. I got it. It's a paragraph 7.
What's the
Let
plan?
us do it. We'll see to it.
Kindly allow this, we will assist to it.
No. Tell me the law. I'm inviting you. Did you raise an objection when they made a publication under Rule 31 or 30? Yes. We are talking law. We are not talking anything. You have come before the court of law. You talk law. If you did not find any objection before the time which is given in the publication, can your objection be entertained by the Then what is the effect of Rule 33(2) of the rules? Have you read that 33(2)?
Yes, that's a bit can be stipulation.
Please read 33(2). If you don't have, I'm giving you a book. Give us.
Perfect.
So how can they go beyond the statutory provision?
So may consider and
but they have said something which is absolutely alarming.
Please.
In the counter, what they have said is absolutely alarming. If you come, we'll
I
see.
appreciate you, Lordship, sir, looking at a larger picture of the issue, Lordship.
We are looking at upholding the law.
Please, Lord.
If the law is clear, nobody would be permitted to violate the law by any means. By any means. When I use the word any means is because of the second paragraph of paragraph 7 of the contract. You can take the law in your own hand.
No, I bow down.
Then
our only intention was to assist your Lordship in this matter. Therefore,
what assistance? I am asking. Tell us that what should we interpret this provision?
Assist. So far as statutory law is concerned, your Lordship, I do not have any quarrel with that.
Can the authority go beyond the statutory provision? I am asking. Assist us with the law.
I have to say they cannot be.
Nor a High Court can issue a mandamus to act contrary to law.
Please.
So, the law is very clear.
Your Lordship may consider the matter and decide on this. So, your Lordship, that we are only
nothing an issue. And who will be responsible for the loss which he has suffered because of your act, which per se is illegal and not acceptable in law? Who will suffer?
I appreciate the Lordship. This common man cannot be expected to know, your Lordship, all these.
Ignorance of law is no
excuse. I completely
come before the court.
Completely.
So, when you know, why don't you? It's your responsibility when they have approached that this is the law. One has to respect the law.
Authority has to verify.
You also, as a citizen,
I doubt.
Will you not respect law?
Please.
Yes. The law is very clear. On the face of it, it is clear. We hear you and then not there.
Without admitting the IO, Lordship would hear us.
We will allow this IO.
Please.
And then I have invited you.
How done?
Argue on the proposition of law that what right you have. You may have remarks, but if every steps have been taken, because they say that they took steps as permissible under Rule 31,
yes.
They took steps as permitted under Rule 32, and thereafter they renewed the license. Now 33(2) comes to play after they renewed the license. They say I can't entertain this objection, but the role of your client has been reflected in the counter. Are they supposed to behave in this fashion? Just, I would say, making the law a mere paper. Yeah. No, sir. Have you got the copy of the counter? Show him the subparagraph. What the authority has apprehended.
Law and order.
Are you supposed to do that? Can you?
May I draw your lordships?
Not expected.
I bow down. I completely bow down. I am in complete agreement with the lordships, and I have no problem with the statutory. So far as your lordship
Sentiment, can
appreciate.
the sentiment swayed the law? I'm asking. Another, I know where you will head. I know. Now tell me, can an emotions, the sentiment,
Your lordship would appreciate. Your lordship as a
override the substantive provision of law? One judgment of any court.
I bow down, your lordship. So far as
Rather, the judgments are contrary that no sympathy, no empathy can whittle down the provision of law.
because your lordship would appreciate as a constitutional court what is happening in the surrounding.
Can we, then we'll have to declare this law. Can a constitutional court go beyond the statutory provision of law?
I'm just appraising your lordship what is happening in the ground.
Maybe ground reality. Why you did not raise an objection when this publication was done?
Right, your lordship, due to
So,
some ignorance.
if it is there,
Governors independently come.
I tell you, we could have entertained your prayer had not Rule 33(2) is there.
Statutory.
If it was not in the statutory book, in such language, you would have appreciated.
Prescribed timelines.
After 33(2),
We'll do some
no, sir.
We'll do some homework, sir. Your lordship.
What homework? The law is there. You are a legal expert. You know the law. What a impression one will gather after looking at it.
Some time your lordship.
Who will bear the loss?
I appreciate it. It's the difficult in part of the.
Ultimately, if the authorities have also come in his support. He has read paragraph 7.
Please.
He says that he is legally sound. He has all the legal rights. But because of you
Apprehending law and order.
apprehending, he says that
Because the
just imagine.
because the
Okay. Use that legal maxim.
also fairly submitted that it will be the teeth of sub-rule 2.
Is what problem? Otherwise, had it not there, position would have been reversed. Yes.
P7 will say Bray may be taken up next week.
No, finally, application for vacation stay, my lord. Due to status quo, my petrol pump is stalled, my lord. And the license period will be.
You are for the
Copy number 5, my lord.
number 5.
Yes.
Which item?
27.
Let's just go.
Hmm?
Yes, 27.
What is the stay order?
It's ISPO has been delivered.
My petrol pump was well. Constantly the status quo passed, my lord. I already invested in about.
Where is the status quo? I do not know.
Yes. That is my lord. Order date.
Oh, acha, niche. Sorry. Giving them last chance because you are suffering from 4-6, but you'll have to come. Next week, your 3-6 will have to come.
28.
The entry model.
Convince my brother.
Because my date will be expired, my lord. The 1 year.
Only till minutes, only till next.
Convince my brother.
Lord, in item number 28, I am
Item
appealing
28.
on behalf of the respondents.
There is beginning of 95 days filing document, madam.
Can your lordships hear me?
Madam.
Yes.
Lord, I am appealing on behalf of the respondents.
Which respondent, sir?
The corporation, in fact, all the respondents are the either the office of the corporation or the officers of the corporation. Orissa.
You are appearing for Odisha Hydropower Corporation.
Yes, my lord.
Yes. What do you say about how many days delay?
Lord,
90 days delay.
Lord, 100 days delay. Lord, I am appealing on behalf of the respondents. Your lordships on 2/5/2025 issued notice on the question of limitation only.
Yes. So we have to consider it.
Yes,
So
my lord. I have filed my.
Say about the condonation application, please.
Yes, my lord. If your lordship will look at paragraphs 2 and 3 of that application.
IA 1487.
Yes, my lord. That is the section 5 limitation.
Yes, paragraph.
That's the only ground which has been taken.
Paragraph
2 and 3.
Yes.
That the aforesaid appeal ought to have been filed within 23/11/2024, but after obtaining the certified copy of the order, the petitioner was suffering from old age diseases, for which the appeal is not filed on time, for which there is a delay of 95 days in preferring the appeal. That after recovery from illness, the petitioner handed over the file to the conducting on the first week after preparation of the appeal memo, and the same is being filed today. And that's the ground. That's the sole reason for the delay. And then after your lordships issued notice.
Yes.
On 2/5/2025, on 7/7/2025, a further affidavit has been filed, enclosing certain prescriptions of the doctor.
Correct. Yes.
And these prescription, if your lordship will look at the medical certificate of the prescription dated 10/2/2025.
Yes.
That says that the petitioner should go for the appellant should have gone for an MRI.
Yes.
But no MRI report is filed here. It appears that the entire thing.
Can you force a person to go by the advice of a lawyer or of a doctor?
My lord, if he is filing an application for condonation delay relying upon the doctor's certificate
Now
and prescription.
the court will look into the overall situations, not to look at in a jealous manner to find a fault here and there. If the sequence shows that there has been some kind of a problem.
The diagnosis is lumbar spondylitis. I leave it to your lordships. I'm not going to proceed further if your lordships are inclined to condone the delay. But I had to point out that if at all these were the facts which were brought to the notice of the court in July, it should have been filed in the application under Section 5.
Nowadays, you are aware, sir, that's the irony of the things, because I find here that everything is done in a very casual manner.
But I leave it to your lordship because
that is what one has to understand. So we granted him a leave to file all those documents. And now those documents have been filed. And these are predating those, the application. It's not that subsequently. Limitation, sir. What do you say?
Because
and nobody gains anything by delay. What is the matter about? Why you are challenging the order?
Challenging the order, my lord, to
what is the matter about?
Matter with regard to the height punishment has been imposed for 5 increments without cumulative effect.
What?
Without 5 increments top without cumulative effect. And the senior will be restored. After 5 years, it will be automatically restored. They have not.
So you are simply challenging that the quantum of punishment is not appropriate.
So
Yes,
Huh?
exactly.
Exactly. So now, so far as the sentencing part is concerned, there is no grievance. Only thing is how it is to be penalty should be imposed is a grievance.
Yes.
So you have suffered a penalty.
Yes.
Yeah. Now what is the law? Mr. Mishra
Milord, if you
is not challenging the procedure of the disciplinary
Milord, that's true because your lordship had
only
confined.
the sentence, a penalty part.
Yes, my lord, your lordship had confined the notice only to the application for condonation of delay. So,
So
your
let us,
lordship will issue notice here.
yes, I will give you. That definitely I understood. Applications. This is an application for condonation of delay in filing the instant appeal beyond the statutory period of limitation provided therefore. Stop. Called it. Yes.
This is the read of by the appellant against the orders of the honorable court simple bench, WB number 111 of 2017 and publication number 1617 of 2008. As the appellant is a poor lady with having physical personal injury and condemnation of disease.
How much days delay? Have you served the copy?
Notice issued, not.
Notice, huh?
Not to AD, not yet back, my lord.
Not yet.
Not yet back.
Keep it on 27. Are you appearing?
But I am for state, private respondent, you lots of.
Oh, the actually acknowledgement due card has not returned, so more than a month has expired from the date of service. Let us, madam. First thing is service is very important because they will come and say that I have not been served and that pass the order. Then we have to recall it.
12/8 the order was.
No. When the notice was the issue, the notice is
20th. 20th August, office is written.
Notice is more than 1 month.
Are you not appearing for all the respondents?
Well, it's before the notice has been issued.
State commission. State commission.
Yes, state commission with for person.
That's the pro forma respondent. So it has got nothing to do with this. You are the main contesting respondents.
Yes.
Pro forma has nothing to do. I was also surprised because we can also raise a presumption of due service. More than 1 month has expired from the date of the service. Under the the General Clauses Act.
You may pick up to 29th, you may hear it. You may hear it on 29th.
No, condonation.
Donation, my lord.
Yes.
Much delay.
Lago. Although the acknowledgement. Anybody who was asking, because I have to go for some administrative work, somebody was asking for extension. 36. Who is for the other side? Who is appearing? State 36. You are. Extension.